Get ready to take a flamethrower to the official narrative and learn what the elites don't want you to know. You're listening to The Tom Woods Show.
Hey everybody, Tom Woods here. It is episode 2511 of The Tom Woods Show, and I am so delighted to have Tracy Beanz back on here to talk to me about this Murthy versus Missouri case and what the Supreme Court just had to say about it. She's been following it more closely than anybody I know, possibly even including the plaintiffs themselves. And I've known Tracy since back in the old Ron Paul days together. We would cross paths at various events, and here we are crossing paths again, doing the same kind of thing, fighting against the bad guys. You can follow her on Twitter, X, at Tracy Beanz with a Z, and also check out uncoverdc.com, her website. So welcome back, Tracy.
Thanks for having me. You know what's funny? The first time I was on your show, we were talking about the DNC WikiLeaks emails, and they've just been removed from WikiLeaks' website. And now here we are on a court case of national import. So,
yeah, you and I don't, we don't screw around with dumb topics. Like, we focus on what matters, what's really going on in the world. Holy moly.
Yeah.
Well, I read what you had to say. I read what Janine Eunice had to say, who's prosecuted, who's been involved in a number of these COVID-related cases. Then, of course, I went over to Jay Bhattacharya's Twitter feed to see what he had to say, and he's kind of down in the dumps about it. And I think he had also been a little bit concerned, based on the opening arguments, that the case was not being made as strongly as it should have been made. So I like that you take a sober tone in this, and you say, in effect, the easiest thing in the world would be to become hysterical about this, but let's take stock of what's actually happened. And yes, it's a setback, and yes, it's going to make our lives difficult. But let's make sure we understand exactly what happened here. So let's start with what the case was all about. You and I follow this stuff all the time. Not everybody does. So what exactly brought all these people to the Supreme Court? What were they talking about in this case?
So the suit was brought because a number of individual plaintiffs, along with the states of Missouri and Louisiana, said social media companies are censoring Americans after being coerced by the federal government. And we would like to bring this case to prove it. And also, Judge, we would like a temporary injunction to stop the government from doing that while the case goes on. And in order to get that temporary injunction, Judge, we would like you to grant us preliminary expedited discovery or information gathering power in the case. And all of that was granted. And so they went through this expedited discovery, and they got numerous examples, I mean, too many to list, of the government, in fact, threatening social media companies to censor or else. And the judge on July 4th of last year ruled, yes, there will be a preliminary injunction put in place to stop the government from doing this as this litigation continues in the court. The government, of course, Tom, appealed because they want to be able to censor American speech. And it went to the Fifth Circuit Court of Appeals. At the Fifth Circuit Court of Appeals, they upheld the lower court's decision and said, yeah, we're going to put this, temporary injunction in place. You guys have standing. You've obviously proved that you have a likelihood of succeeding on the merits. So we're going to uphold the lower court's decision. And then the government, again, challenged that ruling up to the SCOTUS. And that's where we're at today with the Supreme Court deciding to remand the case back and overturn the ruling on the temporary injunction. So that's it in a nutshell.
Okay. So there's a lot to go through. You have a long thread that I'm looking at right now where you go through the text. And I have to say, I think people don't realize that you can generally read a Supreme Court decision if you're a person of reasonable intelligence. It's not written, there'll be some references you're not going to know. Nobody's going to know all these crazy precedents, but it's written in plain English, so anybody can just go ahead and read it for themselves.
Yep.
And there are a lot of things to come to grips with here, because on the one hand, so we've got on the one hand, the official opinion of the court is to say, we are not actually entertaining the merits of the case as much as we're saying that the plaintiffs in this case lack quote unquote standing. But then in the dissent, which was written by Alito and joined by Thomas and Gorsuch. Alito says, in effect, says you're defining standing in such a unreasonably narrow way, and I can show you that the plaintiffs, and he picks one plaintiff in particular, clearly meets every requirement for standing, and so really the court is ducking the case rather than. So in other words, the court didn't have to make this statement. The court could have actually judged the merits of the case and should have sided with the plaintiffs because the evidence is very substantial. Now, you claim in your thread that it looks very much as if the justices who joined in the opinion of the court had not actually read the record. They were just going on what they heard said. And so why do you think that is?
A number of reasons. First of all, the three dissenting justices told us that was the case once prior. So when the case was brought before the Supreme Court and they agreed to hear it, they placed a stay on the order they placed a stay on the temporary injunction. So everything was basically status quo. And the same three judges dissented that stay, which is very rare. It's not very common that happens. And they wrote, the other justices haven't even read the record in this case as of yet. To make this decision is irresponsible. We just want to be on the record saying that. So I knew from then, and the attorneys should have known from then, that they did not spend the time. It is copious. There are thousands of pages in this record, Tom. It's not like it would take them a day, okay? But it is one of the most consequential free speech cases this country has ever seen. So for them to show clearly by their opinion that they do not know what's going on in this case, there's just no way you could know and come to the decision they came to. And not only that, like you mentioned, they're setting a precedent here that's going to be highly damaging for many defendant or many plaintiffs in the future. Whether they're Democrat or Republican, it doesn't matter. The way that they have pigeonholed what they require standing to be to sue the government and even win at this point is it's abhorrent. It's ridiculous. It's impossible almost to meet. What they're basically saying in this case is the plaintiffs can't prove they'll have any future harm because there's no proof that the government will continue to do what they're alleging they did in the past. Well, does that make sense to you at all? How is one supposed to prove future harm? Now, what they say is if the plaintiffs were also suing for damages on the things that had already happened, then they would maybe have a little bit better of a case. But because they're not, because they're only using those things as predictors of the future, they have a higher standard to meet for this to continue. But again, they didn't judge anything on the merits because if they were going to do that, they wouldn't have been able to put an opinion in like they did today.
Okay. Now, you predicted that it would be 6-3 in this way, and it was 6-3. So what did you think all the way back, months ago? What did you see going wrong that we would have gotten an outcome like this?
It was very, very weakly argued. And in a case when you know that the other justices haven't read the record and you're standing there, I just, look, I'm not an attorney, okay? I'm not. I just focus on the law. So I've seen and heard, gosh knows how many hearings and oral arguments and whatever. And knowing the record in the case as well as I did, I knew that they fell flat. They didn't do a good enough job arguing this case in front of the Supreme Court. When one of the justices said, well, what if the government wants to stop social media companies from letting a trend where kids are throwing themselves out of windows? I think we had this discussion, actually. What if they want to stop that? Shouldn't they have the power to be able to stop that? And you and I will both agree the answer is absolutely not. No, that's not the way the case was argued, though. It didn't pull enough factual information. They didn't use the right examples from the record to make their points. It was weakly argued, and I knew that was going to be a big problem.
You say because you say in there in your thread that the Supreme Court almost tells the plaintiffs they should have been suing for their past harms rather than harms they will experience in the future. Do you think that throughout this decision there are maybe unintentional, but sprinklings of hints as to how the plaintiffs might go about the case differently if they want to have a better outcome in the future?
100%. Yes, there absolutely are.
You think their team is going to pick these tidbits out? Cross your fingers?
Truthfully, I do. They're really great. I've interviewed a lot of them. And I've had, Attorney General Bailey on a few times. I had, when he was the Attorney General, Jeff Landry on. I've interviewed Liz Murrill, who's now the Attorney General in Louisiana. They are sharp and they really, really care. And I think they will pick this stuff out. The other thing that very few people are probably going to talk about when it comes to this case at SCOTUS is they acknowledge without acknowledging that the government is coercing social media companies, but almost gaslight you, Tom, into believing that you're just supposed to be okay with it. It's like I said it a couple times. I think in one of the posts I made, I just said, "Who wrote this?" And if you read it, it's almost scary. It's almost Orwellian the way that they're telling you, "Oh, but this is okay," or you didn't really prove this because you have to prove, like even in a criminal case, they want you, basically what the Supreme Court is saying, they want a plaintiff, Jill Hines, to prove that on this day at this time, the government emailed Facebook and said, "You'd better take down Jill Hines' post about COVID-19 vaccines. Otherwise, we're going to come to your house in the middle of the night and we're going to take care of you." That never happened. The government knows not to speak that way. So if that's not proven, then you don't have standing or you can't prove that they harmed you. But that's insane. And that's why I say it's setting such a terrible precedent. I'm sure you could think of examples of how this will be bad in the future.
Hey, everybody, here's how to unlock a 12% return on silver. Most of the time, you buy gold and silver and you just sit there with it. Now, that's better than what most people do, which is not buying any gold and silver. But thanks to Monetary Metals, where our old friend Jeff Deist is now, you can put those precious metals to work for you. Silver, by the way, is a tangible asset, a great way to diversify any investment portfolio. But with Monetary Metals, you don't just own physical silver. You own silver that works for you to generate more silver, growing your total ounces over time. Well, as I said, you can now earn 12% annual interest on silver paid in silver in their latest offering if you are an accredited investor. Click the link in the description or just head to tomwoods.com/silver to learn more. You've heard me talk about Monetary Metals plenty. I've had an account there myself for about 2 years, and they are revolutionizing the way we invest in gold and silver. They've been paying interest on gold and silver for over 8 years, and that helps you grow your wealth in real tangible assets. You want a true alternative to saving in the dollar? Well, you've got it. You can generate a yield on gold and silver with Monetary Metals. Head over to tomwoods.com/silver to find out more. So that's I think what you're driving at in here when you say that the standard that the Supreme Court is demanding is not reasonable, and it's going to be hard for them to meet. Now, you would think that when it comes to something as fundamental as freedom of speech and allegations that it's been violated, that you would think that the standard could actually be fairly low for that, given how much we want to guard against that we would not actually erect ever more difficult barriers to overcome, because this is a fundamental right that goes to the heart of American history. But that's, what do I know? I'm just a guy.
You know a lot, Tom. You know a lot. But to your point, there was just a case last week. I don't know if you caught the NRA case where the government of New York was threatening insurance companies. If they insured the NRA, then they would have a hard time doing business in New York. Okay. That was the crux of it. And they ruled in favor of the NRA. The Supreme Court did. And in that decision, they cite Missouri v. Biden. So some of us were like, you know what? That's a great sign. Look, they cited Missouri v. Biden, the case in their decision supporting the NRA and these insurance companies. I think there was Vula was the name of the case that was decided. And so when Alito wrote his dissent today, he brought that up. He said, we just decided a case last week that we used a lower standard than this. And this is basically the same exact thing. Also, Bantam Books. I'm sure you've spoken about that one, where the government was basically threatening book publishers. If you publish this book, there's going to be problems for you. And Alito said in his dissent to this decision He said, you don't have to threaten someone's life every single day for a threat to have any effect. Meaning one strongly worded threat when social media companies are dealing with government coercion in so many other ways and being fined and things like that, 1 or 2 threats of harm are enough. And their internal emails absolutely prove that. So this is an absurd opinion from the Supreme Court. Again, a punt because they're deciding on, quote, standing and not on the merits. But here we are. So now we have to go back down to the lower court and we have to have this case continue with discovery. And just it's going to be so much harder now, because even if they get to a point where they've got mounds of discovery, they just filed a motion for third-party subpoenas to subpoena Google and all kinds of other third parties for emails that we know were now deleted outside of the spec of FOIA. And it's going to be just really hard for them to meet the bar required. Do I think the justice in the case, or the judge in the case right now, will rule in their favor on most things? Yes. But the Fifth Circuit might be like, do I really want to dance with the SCOTUS again? And it might have a chilling, you know what I'm saying? It might have a chilling effect on them. So
yeah. I mean, my career matters more to me than your case. I don't know that that's the way they think, but you're right about the potential for a chilling effect. So it's not that this is necessarily the end of the road. It's that it's a tough road ahead.
Yes.
Now, of course, one could imagine a scenario in which Congress passes some legislation saying that prohibiting the federal government from behaving in this way. It's just that I haven't gotten very far relying on the U.S. Congress. So
do you want to know what's interesting about that? There is already a law in place prohibiting the government from acting that way. It's called the Constitution.
Well, sure.
They're supposed to, they're already doing things they're not supposed to do. And yeah, I don't know what what Congress we're looking at, but I don't put any faith in them whatsoever, especially not so close to an election, Tom. It's too close to do any real rulemaking close to an election. So,
I like when you said in your thread, you're reading the dissent now, Alito's dissent. And you say, I can already tell I'm going to agree with everything they say because they're right. And some dissents make for really compelling reading because there are great dissents where the dissent, sometimes the dissent is just filled with righteous indignation. It cannot believe the court has behaved in a particular way. And it brings this indignant tone to the dissent. And certainly you do get some of that in Alito. He is saying he recognizes clearly the significance of the case and is appalled that the court's opinion has gone this way. And I keep saying this is a project I'll complete when I'm 120 years old, but I keep saying a really interesting book somebody could put together would be called Great Dissents. And you take some of the really good dissents over the years when there have been constitutional outrages, and you get the dissents in there, and there's your constitutional education. All the things the dissenters are saying are all correct.
Well, unless they're Sotomayor and Kagan.
Well, I didn't say they were all great dissents. I'll pick which ones go in there.
You
Thank
do
you
that.
very much. But okay, so what's the overall thrust of Alito's argument? I mean, I suggested earlier that he's saying that there's no reason to dismiss this on the grounds of lack of standing. But it seems also that he is arguing the merits of the case.
Yes, he is. He picks one plaintiff and her experience, Jill Hines from Health Freedom, Louisiana, who, by the way, has been instrumental in all of the legislation that's coming out of Louisiana right now regarding vaccine mandate and so many amazing things they've accomplished. But he details just the story of her and some of the posts that, or the things she's experienced. And he details the White House threatening the social media companies, specifically Facebook, to do what they want or else, accusing them of being murderers, while also holding another piece that they're going through right now in terms of antitrust. And they've been subject to fines of billions of dollars. So Facebook is sitting in the corner like, we really need to listen to what they're saying. The White House is saying, do this or else it'll be really, really hard for you. We don't like working with you. We can't count on you. And he details it all. It's all in the record. There is just no way that these judges could have actually read that and then be like, oh, they're not really actually coercing Facebook. They're just merely suggesting that Facebook follow their own moderation policies, which they had in place before any of these people suffered any injury. But none of that's true. So Alito is detailing all of this in the dissent and saying, how can you say that? The social media companies corrected and changed their policies in response to what the government wanted. How is that not coercion? So now you've got government. He basically said what I said. If you wanted it, before I read it, I said, if you wanted a manual government on how to censor Americans without having to worry about getting into trouble in the courts, read this. It's there for you right now. Like the entire opinion, you can just read it and follow right in those very, very stringent lines. You could basically do everything except say, take this post down or else I'm going to rip off your Section 230 Band-Aid. Everything else would be fine. And Alito details all of that in the dissent. It's beautiful.
Yeah, there's one line, I don't remember which official said it, and whether it was direct. I think it was directed at Facebook, where they were pointing to some post and saying, how is this not violative of your policies? And they didn't hear back. And so whoever this creepy official was wrote back and said, these questions were not rhetorical.
Mm-hmm.
Like, whoa, what does that mean? So yeah, I intend, I'm expecting an answer. I mean, what again, if you look at these communications, what can you conclude other than they were asking for what they were asking for? It's that you can see in their communications. When I was just in the kitchen just before we started recording, I mentioned to my kids that I'm recording an extra episode. So one that I recorded just before this, I'm going to push off to next week because this is so important. I said, so I'm doing a little extra recording today, but I had to because this really important Supreme Court case. And so I told them about it, and a few of them knew about it already, but one of the 14-year-old said, oh, is this that free speech case? I said, yeah, as a matter of fact, it is. And I said that they're basically what the fundamental thing is that what the question is, can they, the real merits of the case really boils down to, can they let's say, outsource the suppression of speech to third parties? That really is what it's all about. And then if you were to get into the specifics of all these communications, you could decide whether or not these communications really did amount to the government saying to third parties, you suppress speech. But I was saying to my kids, it's really just as dumb as it sounds. I mean, it is obviously, if I may use a nice word from Alito, it is clearly a ham-handed way to get around the First Amendment, and that's actually what we're talking about. But as you say, the examples that Alito gives here at least establish that a very, very disturbing trend was afoot, and that people were named by name, and that the federal government obviously was putting pressure on these platforms. What other conclusion can we draw? So what exactly? So right now, then, that means that as a result of what we've just read, what's the next step? They go back to the Fifth Circuit, or what happens now?
No, it goes back to the district court, and the district court. Yeah, the case will continue as it were. They, again, like I said, they just filed for third-party subpoena power to subpoena Google for Fauci's deleted emails that he deleted outside of FOIA or sent using Gmail, as they admitted. And I gotta tell you, Tom, 2 times when committees came in handy were, number one, in this case for Flaherty's emails and things, and number 2, in this case, for the FOIA misgivings that we've recognized. So if they're going to be good for anything, I guess it's just to plant the legal side of things. So it'll go through that, and then they'll have a discovery schedule set, and this case will just move forward. I truly I need to speak to an attorney to figure out, because it was just merely on the injunction part, but yeah. I don't know if they'll file another motion to dismiss on standing, even though for the case, not just for the injunction. I doubt they will, but they may, because that's been adjudicated twice now, over and over again, and they've survived. The plaintiffs have survived the standing thing, because if one of the plaintiffs has standing, the rest of them, the case must continue. So even the Supreme Court argues the majority argues that Jill Hines has standing, the most standing out of everybody anyway. So it'll just continue. And then we'll just have to hope that they do find that actual literal smoking gun in the hand of the government as they're pulling the trigger. You know what I'm saying? Like, that's what the Supreme Court is saying it will need. So even, let's say it goes to jury try. If it goes to jury, which is what they want, they're sitting in front of the jury, they win. And then the government, appeals it to the Fifth Circuit, and the Fifth Circuit looks at whatever that appeal is and then affirms the lower court or the jury decision. And then it goes to the SCOTUS. What do you think is going to happen at SCOTUS now? On their own precedent. That's the problem.
Well, Jay is saying that now it becomes kind of a political issue. Now we have to get people running for office on record. How do you feel about censorship, social media censorship that's basically coerced by the federal government? How do you feel about that? And he says that since lower bureaucrats carry this censorship out, we need to ask everybody all the way down to dog catcher where they stand on this and make it into a political issue and shame people who favor the suppression of speech. I wish I had more confidence that the American public, by and large, opposed the suppression of speech, but I think some of them, all you have to say is it's an emergency and their faculties just go right out the window.
Yeah, we've seen that. I think, and I don't want to speak for him, he's obviously a plaintiff in the lawsuit, but I think that he was misled initially by the reporting by some that was incorrect about this case. And I could, like, from reading his initial tweets about it, or posts, whatever we're calling them nowadays, I could see that it seemed like he thought the case was done by the Supreme Court ruling because it was misreported significantly. But I also think that this should have already been happening if that were the tack we were going to take. That's an activism way to approach it, and more power to him. But I still think we need to do this judicially at this point, because what is Congress going to do? Hold itself accountable? We never.
Yeah, I know, but it really is the puzzle that we have to deal with on all levels, because Joe Biden bragged that he would ignore the Supreme Court, and other presidents have bragged this way. And sometimes the Supreme Court's wrong too. So then you have that can of worms. I mean, it's how do you tame this institution is the fundamental problem.
Yeah.
And there are a lot of ways you can try, and some of them involve using one part of it to tame the other part. Sometimes that works, sometimes it doesn't. And then Thomas Jefferson had confidence that you could always, in the last resort, appeal to the American public. Like, that was his attitude when it came to the Louisiana Purchase. If you thought that was unconstitutional, which he did not, and a lot of people actually did not think was unconstitutional, but if you did, then he thought, I'll throw myself at the mercy of the public and they can dismiss me from office. That's the old Jeffersonian view of the hardy, self-reliant American who's informed and ready to take part in civic affairs. And this seems like something from Mars, unfortunately.
As Alito says, it is the marketplace of ideas now on social media. And the sad thing is, if you wanted to get that message out today, you would need social media to do it. And it's kind of hard to do that when you can't say what you want to say on social media. It's a circular firing squad. So I think we need to get back out on the streets with signs and bullhorns, because that's really the only way we're going to reach people, when the main way to get information out, like, you don't know how many lives were saved during COVID by some of the, alternative reporting that myself and others were doing. And that's the other thing. You don't need to be right for you to be free from the government censoring what you're saying. You can be as wrong as anything. They still can't do it. But they're doing it anyway. And another facet of that, Tom, too, is they're not only directly doing it themselves, they're using taxpayer-funded NGOs to do it too. So it is a big ball of yarn. And there's another case about that in the same court, by the way, with the same plaintiffs. So it's a big ball of yarn. And today wasn't a good day for free speech, that's for sure. But it also wasn't the end of the most important free speech case in our country's history either.
Hey, everybody, let's take a minute to thank our sponsor, Persist SEO. If you are getting buried by your competition online, Then build your brand, your reputation, and your lead flow with digital marketing by Persist SEO. If you are a small local business trying to compete against large companies in the service industry, then increase your visibility with Persist SEO. Or what if you have low or no leads coming in on a consistent basis? Well, then website search engine and conversion optimization can help move the needle to a more prosperous business model for you. Are you tired of cold calling and networking, meeting places getting shut down? Use your website as a lead generation engine. Or what if you're not showing up for your services in the search engines? Well, get found with Persist SEO's expert search engine optimization. All you have to do is call 770-580-3736 or visit them at ineedseo.help for a free website audit and consultation. That's 770-580-3736 or ineedseo.help. But now we know another question we have to ask potential Supreme Court justices. We have to add to the list. This is one of them. Oh, I have to say, one thing that I was curious about was what's Elon Musk going to say about this? I mean, he's got this big platform, and it was named in the case. Obviously, the activities were before he was around, but what's he going to say about it? And I, to be honest with you, I kind of expected him to make a semi-dramatic announcement that his platform, doggone it, is going to, let people speak, and that's what it's all about. And so far today, now I'm not holding this against him. I mean, he can take his time, but I'm looking on his feed right now, and the most recent post is 2 hours ago, and it's a picture of a hawk.
Oh.
So, well, I don't know. I thought he would say something.
He's kind of involved in the case. Like, if you've noticed, the social media companies have been very mum on this one, and they're kind of third parties to it, right? I mean, that was one of the critiques that the Supreme Court had, was that you're not suing the platforms, you're suing the government. You should be suing the platforms. No, that not in this particular case. But they're quiet. They're stuck between a rock and a hard place, because I can guarantee you none of them want to come out and jeopardize Section 230 and say that they were voluntarily taking down things as per their, you know what I'm saying?
Yeah. No, I hear that. You're right. I actually hadn't thought of it that way. But can you take a minute to explain? Everybody talks about Section 230, what that means.
Okay. Very simply, it means that platforms aren't supposed to be making editorial decisions about content, meaning they're not supposed to be taking down content based on viewpoint, or they can't be publishers. They have to be basically platforms. They're not allowed to act as publishers, deciding what people can and can't say. Because what happens is Section 230 protects them if somebody like the Christchurch massacre person or whatever streams their murdering live on Facebook. Facebook can't be held liable for that because of Section 230. But if they're making choices about what they will and will not leave up on the platform, they become a publisher, not a platform. And then the rules all change for them. So this is a very hairy, that's the best I can do in a very basic way.
No, that's really good. Now, yeah, I get it.
So that's basically what they're up against right now. If they come out and say, we did this voluntarily, the government didn't make us do anything, their Section 230 protection is in jeopardy. And if they say the government made us do this, the government's coming after them. So they've been relatively quiet, and they're also responding to discovery requests. It's just it's an interesting marketplace right now with that.
Can I ask you a slightly unrelated, but not entirely unrelated question, unrelated to the case? Mm-hmm. What have you thought about Elon Musk and his version of Twitter? I'm too old fashioned. I'll be calling it Twitter. My grandkids won't know what on earth I'm talking about.
Are your grandkids on X?
Oh, thank goodness I don't have any grandkids yet.
Oh,
I mean,
okay.
My theoretical grandkids someday.
I was going to say they're a little young for politics.
That's right. But I don't know. I have friends who have grandkids, but I'm bound to have a bunch of them because I have 5 daughters.
Yes.
And they're all going to talk about X, and I don't know what their old man's talking about. But what do you think about him?
I think that a lot of us that were banned and let back on are still in some weird censorship box that they haven't been able to figure out.
Oh.
Algorithmically.
Okay.
For example, incorrect reporting about Missouri v. Biden, when truthfully, I mean, you're not a journalist per se, Tom, but This is a story I've been covering almost exclusively for 2 years. Very few people have touched it because it's complicated. And everybody, pretty much a lot of people know, okay, well, when there's news about this, I'm going to go see what Tracy says about it because it's been
That's
something
what I did today.
Okay. The people who had not been censored off of X were posting incorrect information about this, and it was going buck wild. I got maybe 40 retweets on my post about it. And I find that a little bit hard to believe. So I'm glad I have a voice there, but I still think I pay for the premium plus. I see ads all the time. Like, it's not right. It's not right. There's something wrong. He needs to fix. Something's wrong. That's my thought.
I get that. Okay. Because when I say favorable things about him from time to time, and I don't agree with him on a lot of things, and that's, fair enough. But I think that what's happened on Twitter, I mean, it is possible to talk about things that were just not possible to talk about anywhere. Yeah. And I really do appreciate that. Mm-hmm. But I write about him, and then I'll get people saying, oh, but did you know he wants to put a chip in your head and stuff like that? And, then I don't know what to tell you people.
Did you I actually looked into that. I was really curious about what Neuralink was. Like anything, there's potential for malfeasance, right? I mean, like anything. But the gentleman who has this implanted, his entire life is changing because of this thing. He's thrilled. He's a paraplegic, or quadriplegic, I should say, who's now like literally moving mouse pointers around the screen with his mind, with his thoughts, and able to text, and able to do things he never was able to do before using Neuralink. And it was pretty amazing, actually. People say that Elon Musk is can you find a perfect person? Outside the good doctor, I haven't found one.
No, I haven't either. And when we come, not close to a perfect person, but when we find like a 75% decent person, there's a kind of person in our circles who just can't do anything other than focus on that 25. Mm-hmm. And they have to email me to let me know about it, that this person's a fake and this one's that and this one's that. And so on the rare occasion when you and I have a victory, we do have an occasional victory, it's always a sham and we're too dumb, we're falling for it and all this. And if that's how you want to live your life, go ahead. But I don't want to put a bullet in my head,
Amen.
I want to be happy.
I totally agree. I'm so tired of the doom criers everywhere. It's frustrating. I mute them now because like somebody said something terrible about me on social media the other day, made something up completely out of whole cloth about me. And I was like, you're crazy. Like, there are just crazy people out there. And I think we should all try and find a little bit more joy in our day.
I find, now this is not true of all of them, but I find that an awful lot of those people, when you ask, well, what are you doing? What actual thing are you doing to try to make things better? Because I'm doing a lot of things to try to make things better. I created a whole community of people that's dedicated to how do you survive and thrive under a hostile regime. And that includes raising your kids, generating an income, whatever, all these things, where you should live. And it's all practical. It's not the non-aggression principle. It's not, if the cannibalism were voluntary, how would libertarians feel? Like, it's none of that. It's just all practical stuff. It's my school life program. I'll put the link in the description. And so I really am trying to make a real difference. But a whole lot of the people who can see no positive development anywhere, even when it's staring them in the face, you ask what they've done, the best they can come up with is that they wrote an angry letter to the editor that didn't get published. Okay.
Listen, you're doing something else you neglected to mention. Can I tell you what it is?
Murder mystery parties?
Yes.
Tracy's going to, am I allowed to say?
Yeah.
Okay. So Tracy's going to be at my Charleston, South Carolina murder mystery party in early October. So you should come. It's a dinner. You get the dinner's included in the murder mystery, and it's in a really nice. Actually, I'm negotiating with somebody that we're actually going to have this particular one just outside of Charleston in an actual castle, and it's going to be murder in the blah 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 castle. So it's going to be absolutely great. So if you're not coming to my murder mystery parties, people, I don't know why you're not. So woodsmystery.com. And you can meet Tracy, too, in Charleston, at least.
And you can work with me because I'm really good at these. I'm a sleuth. So,
yes, she is. I mean, look, she's been investigating like the federal government, for heaven's sake. You think she's going to get stumped in some castle? Forget
that
it.
is so exciting. I'm so excited now. I was excited before, but that's crazy.
Yeah, it's because I have a listener who said, look, I got this castle. it's got this event space in it. And how would you like to use it? And I thought, doggone, I have weird people who follow me, but I love it.
You never turn down a castle, Tom.
No,
Never.
That's right. So look, I want you to follow. I'm going to put the link to the thread also in the video description. And again, also at tomwoods.com/2511, uncoverdc.com. Follow Tracy. We'll even call it X. We'll be super pro Elon right now. We'll call it X. Follow her there. Tracy Beanz with a Z. Tracy Beanz with a Z. And look, I just want to say thanks. I mean, you came on to record with me almost instantaneously, like 5 minutes after you finished reading the whole thing. So
yeah, and I have no makeup on, so please don't make fun of me.
I honestly, I don't know what you're talking. I don't see anything wrong with you.
I'm so women. We like to be camera ready, but I'm not. But it's okay. This is too important. Thanks for having me. I'm glad to be here.
Absolutely. No, and thank you. I mean, I thought it was a long shot to say, hey, do you want to come on and talk to me in like 3 seconds? And you did it. So thank you very much.
Sure thing.
And thank you, ladies and gentlemen.
Make yourself and those you love less vulnerable to the regime, both mentally and physically. Get more forbidden information at tomsfreebooks.com and be sure to subscribe to the show wherever you listen. See you next time.
Like the sound of The Tom Woods Show? My audio production is provided by Podsworth Media. Check them out at podsworth.com.